Assalamualaikum and greetings Dr. Rizal. My name is FARAH NURSABRINA binti AHAMAD Kamal A177351. Today, LEHSHENI and I will be presenting on question number 4. We will act as the prosecutor, hence, we will be discussing the relevancy and admissibility of the confession made by the accused. The issue that arises in the present case is whether Tamin's confession is relevant to the facts in issue and admissible as evidence. Section 17 subsection 1 of the Evidence Act 1950 provides that an admission is a statement oral or documentary which suggests any inference as to any fact in issue or relevant fact and which is made by any of the person and under the circumstances hereinafter mentioned. Besides, Section 17 subsection 2 defines confession as an admission made at any time by a person accused of an offence, stating or suggesting inference that he committed the offence. According to the definition of Section 17 subsection 2, for a confession of a person to be admissible, it must be first established that it comes from a person who has been accused of an offence. And secondly, the confession refers to an admission of guilt about a crime committed by the accused person. If these two conditions are satisfied, then, in general, the confession will be regarded as admissible. It can be understood that an admission is a statement which suggests any inference as to any facts in issue or relevant facts, while confession is a statement made that the person had committed an offence. In our current case, Tamin's statement amounts to a confession because the statement is in line with the definition stated under Section 17 subsection 2, which the statement has been established by Tamin himself, and his confession refers to the admission of guilt about the bribery offence committed by Tamin. A requirement for the admissibility of a confession is that it must have been made voluntarily by the accused person. In the case of public prosecutor against Othman bin Aziz, it was mentioned that a confession could be admitted under Section 24 if it was proved to be made voluntarily. Following Section 24, a confession is irrelevant and inadmissible if the making of a confession appears to court to have been caused by inducement, threat, or promise having reference to the charge against the accused person, proceeding from a person in authority and sufficient in the opinion of the court to give the accused person ground, which will appear to him reasonable for supposing that by making it, he will gain any advantage or avoid any evil of a temporal nature in reference to the proceeding against him. According to the case of public prosecutor against LEHSHENI and others, in order that an act or omission may amount to an inducement, threat, or promise, three things must be satisfied. Firstly, one should be able to say that without it, the person would not have made a statement. Secondly, it should be such as will make the person suppose that the advantage to be gained or evil to be avoided will be a temporal nature, and lastly, it should be sufficient in the opinion of the court to make the accused suppose that he will get the advantage. In the present case, we as the prosecutor submit that the confession made by Tamin is relevant to the facts in issue and admissible as evidence. This is because the confession made by Tamin is not influenced by any inducement, threat, or promise having reference against Tamin as stated under Section 24 of the Evidence Act 1950. By applying the principles stated in Public Prosecutor against LEHSHENI and others, Tamin's circumstances fail to satisfy the second and third requirement for an act or omission to amount to an inducement, threat, or promise. It is not wrong to say that Duku and Lamin have pursued Tamin to make the confession, as Duku has given Tamin two options, which are he will need to confess or he will face a heavier punishment. Following the statement said by Duku, Tamin had made his first confession towards the bribery offence. However, Tamin's confession does not fulfill the second and third requirement because Duku's statement will not result in any advantages towards Tamin's confession. Heavier punishment will not benefit Tamin, nor any evil will be avoided. Thus, by virtue of the case LEHSHENI case, Tamin's confession failed to satisfy the three important matters. Furthermore, in the case of Hasibullah bin Muhammad Ghazali against public prosecutor, the court said that the accused must show that he was put in fear in order for the statement to result. Similar to the House of Law case of Director of Public Prosecutor against Ping Ling, it was stated that where an objection was raised in criminal proceeding to the admission of an alleged confession by the accused, the onus was on the prosecution to satisfy the judge beyond reasonable doubt that the statement in question had been made voluntarily by showing that it had not been obtained either by fear of prejudice or hope of advantage excited or held out by a person in authority. Following the case of Hasibullah bin Muhammad Ghazali against public prosecutor, it was mentioned by the court that the accused must show that he was put in fear in order for the statement to result. By referring to Tamin's first confession, it was stated in the case that Tamin decided to confess to Duku just because he was feeling angry and wanting to challenge Duku. The saying, "Okay, aku mengaku puas hati sekarang," does not show that Tamin is feeling afraid or was put in fear by Duku for his confession to result. The behavior of Tamin when the confession was made portrays that he felt challenged by Duku's statement. Thus, it can be concluded that Tamin is not in a fear state when confessing to Duku. Besides, although Lamin wants to punch Tamin, Tamin is able to say that, "Okay lah, buatlah apa-apa yang korang nak, aku reda je lah." Thus, it can be said that Tamin is not afraid of Duku and Lamin, and the confession that he had made is not persuaded by any fear, but merely the feeling of anger and feeling challenged.
Good day to Prof. Rizal. I am LEHSHENI from Firm 18, acting as the prosecutor in this current case with my learned friend NURSABRINA Kamal, would like to continue presenting on the conditions of admissibility. In order for Tamin's confession to be admissible, there are 4 conditions that must be satisfied. Firstly, Tamin's confession has to be voluntarily made. By referring to the definition of voluntary in the case of Datuk Mokhtar bin Hashim and another versus Public Prosecutor, 1983, Tamin's confession is voluntary as the statement has not been obtained by fear or prejudice or hope of advantage held out by Duku and Lamin. The second condition is that the inducement, threat, or promise comes from a person in authority. Although Duku and Lamin are included under the category of person in authority as they engaged in the arrest and detention of Tamin, but there is an absence of inducement, threat, or promise from Duku and Lamin towards Tamin's confession. The third and fourth condition is not applicable to, as if there is no form of inducement, threat, or promise in Tamin's confession, as Tamin's confession is influenced by his anger, feeling towards Duku and Lamin. Not only that, Tamin's confession does not appear to him reasonable for supposing that by making it, Tamin would gain any advantage or avoid evil of a temporal nature in reference to the charge, because Duku and Lamin does not mention that if Tamin confessed to his wrongdoing, he would be facing lighter punishment, but instead, Duku said that he will face heavier punishment if he does not confess. Moving on to the next part, we would also like to argue that Tamin's confession was not obtained by oppression. By referring to the circumstances of oppression, as seen in the case of Datuk Mokhtar bin Hashim and another versus Public Prosecutor, 1983, and R versus Priestley, 1963, Tamin does not face any deprivation of food and drink or sleep, and from Tamin's behavior, we could see that he is not under an extreme discomfort. Hence, there is no oppression in the manner in which the interrogation was carried out by Duku and Lamin. Hence, we as the prosecutor would like to submit that Tamin's confession is relevant to the facts in issue and is admissible as evidence. That is all from us. Thank you.